There are moments in this courtroom that the law cannot prepare you for. I have 31 years behind this bench. I have read thousands of files, and I have learned, sometimes painfully, that the document in front of you and the human being standing before you are almost never the same story. The file said he had broken the law twice, same infraction, same month, documented, cross-referenced, flagged automatically by a state registry that does not ask questions, just numbers, just dates, just a violation and a proposed fine of $800. I looked up from the paperwork. He was standing with his shoulders drawn inward, eyes fixed on the floor, wearing a faded jersey and work trousers with a stain that had survived too many wash cycles. His hands were calloused. His hands were clean. And something about that detail, those clean, calloused hands, told me that the document in front of me was missing the only thing that actually mattered. I had seen guilt in this room. This was not guilt. This was something quieter, something heavier. The posture of a man who had been carrying something for a very long time and had simply forgotten how to stand without the weight. I asked him the question I always ask when the paperwork stops making sense. Why? What he said next silenced every person in that room, including me. Before we begin, drop a comment and tell us where in the world you're watching from and what time it is where you are. And if stories about justice, empathy, and hidden truths move you the way they move me, make sure you're subscribed to this channel. You won't want to miss what comes next. There are cases that stay with you, not because they were complicated, not because the law was unclear or the facts were disputed. They stay with you because the moment you looked up from the paperwork and saw the person standing in front of you, something shifted, something quiet and irreversible, like a key turning in a lock you didn't know was closed. I have sat behind this bench for 31 years. I have seen rage dressed up as innocence, and I have seen innocence so pure it nearly broke the room. I have handed down sentences that made grown men weep, and sentences that made them laugh with disbelief. I have been called heartless, and I have been called a fool. I have gone home and stared at my ceiling and replayed a voice, a face, a single sentence someone said under oath that I could not shake from my memory, no matter how many nights passed. The case of Dennis Elmore was one of those. It was a Tuesday in late November, the kind of morning that doesn't bother pretending to be anything other than what it is, gray, cold, and indifferent. The heating system in courtroom 4 had been reported 3 times that month and fixed exactly 0 times, which meant we were all wearing our coats a little longer than usual, and the bailiff had resorted to keeping a space heater behind the door he hoped no one from maintenance would notice. The fluorescent lights above hummed at a frequency that, if you sat beneath them long enough, began to feel less like light and more like pressure. Someone had brought coffee. The smell had permeated the room and then gone stale. What lingered wasn't the good part of the smell. It never is. I arrived at 7:45, as I always do. My clerk, Patricia, had already arranged the morning dockets on my desk. 7 cases. Nothing unusual at first glance. A parking violation dispute, 2 minor civil claims, a noise complaint that had somehow escalated to a formal hearing, and 3 regulatory infractions. I read them in order. I initialed what needed initialing. I poured my water. Then I read case number 6. I read it twice. I set it down. I picked it up again. There are documents that are technically complete, every box filled, every code cited, every number correct, and yet feel, in some fundamental way, like they are missing the most important information. This was one of those documents. It told me what Dennis Elmore had done. It told me nothing about who he was or why. And in my experience, the why is always the only thing that actually matters. I placed the file on top of the others and told myself to keep an open mind. I had learned over 3 decades that the story the paperwork tells and the story the person tells are rarely the same story. My job, the real job, not the one described in the Judicial Code of Conduct, was to find the place where those 2 stories met. The session began at 9. He came in after the civil claims were resolved, and the noise complaint had been continued to a later date. I heard the door before I saw him. Not a loud entrance, quite the opposite. It was the entrance of a man who was trying very hard not to take up space. The hinges gave their usual low complaint, and then there was a pause, as if he needed a moment to gather something before he stepped fully into the room. When I looked up, I saw a man who appeared to be somewhere in his mid-30s, though exhaustion had done the kind of work on his face that usually takes a decade longer. He was broad across the shoulders, the build of someone who had spent years doing physical work, but those shoulders were drawn inward now, curved slightly forward in a posture I recognized immediately. It was not the posture of guilt. It was the posture of someone who has been carrying something very heavy for a very long time and has simply forgotten how to stand without the weight. He was wearing a football jersey, faded to the point where the number on the back was more suggestion than fact, and work trousers with a dark stain along the left thigh, oil or grease, the kind that gets into the fabric so completely that no amount of washing reaches it. His hands were calloused and clean. That detail registered somewhere in the back of my mind and stayed there. The hands were clean. Whatever else was happening in this man's life, he had made an effort this morning. He stood at the defendant's position and looked at the floor. Not at me, not at the room, at the floor, at a fixed point somewhere around 2 feet in front of his own shoes, as if that was the only stable thing available to him. The public defender beside him, a young woman named Carol Reeves, who I knew to be thorough and genuinely committed to her clients, placed a brief hand on his forearm and said something quietly. He nodded once. He did not look up. I looked at him for a moment before I spoke. Patricia was ready with the case number. The fluorescent lights hummed. Somewhere in the building a door closed too hard and the sound traveled through the walls like a distant clap of thunder. I cleared my throat, and Dennis Elmore finally looked up. His eyes were dark and deeply set, underlined by shadows that spoke of nights that had not offered much in the way of rest. But they were present, fully, completely present, in the way that the eyes of people who have survived real loss tend to be. People who have been through the kind of grief that scrapes everything soft away tend to look at you like that. Not emptily, the opposite. They look at you as if they are rationing their attention very carefully because they have learned, at considerable cost, that not everything deserves it. I held his gaze for just a moment. Then I opened the file. 56. The paperwork in front of me listed his full name, his date of birth, his address, an apartment on the east side of the city, a zip code I knew well, the kind of neighborhood where the laundromats are always full on Sunday nights, and the corner stores close early in winter. It listed his employer, Riverside Property Management, Maintenance Division. It listed his hourly wage. I noted the hourly wage and said nothing. Rosa Vega, the assistant prosecutor assigned to the case, stood and began reading the charge in the efficient, unhurried manner of someone who has read similar charges many times before and has long since stopped hearing the weight of the words. Her voice was clear and professional. She cited the statute. She cited the dates. She cited the 2 donation centers, the Caldwell Street Medical Center on the 14th and the Marsh Avenue Plasma Clinic on the 22nd, 8 days apart. The minimum required interval between donations was 30 days. He had been compensated $50 at each location for a total of $100 in what the code described as unlawful financial receipt. The proposed penalty was $800. She placed her summary on the table with a quiet, precise sound and sat down. The room was still. I looked at the numbers on the page in front of me. $800. For a man whose hourly wage told me that $800 represented something close to 2 full weeks of work after taxes, for an infraction that had earned him $100. I have always believed that the law, at its best, is a living document, something that breathes and bends toward justice when justice requires it. I have also always known that the law, at its worst, is a machine that processes inputs and produces outputs without ever once asking what those inputs cost the person who provided them. This felt, in that moment, dangerously close to the second thing. Carol Reeves entered a plea of not guilty with mitigating circumstances and requested the court's consideration of the defendant's personal situation. It was the correct legal move. It was also, I suspected, the only card she had. I made a note. I set down my pen. On paper, the case was not complicated. The violation was documented. The infractions had been cross-referenced by the State Health Registry, which flagged duplicate donations automatically. Dennis Elmore had not attempted to deny that he had gone to both centers. There was no conspiracy, no elaborate deception. He had simply walked into two buildings on two separate occasions and done the same thing twice. The system had noticed. The system had responded. The system had generated a document, and that document had eventually found its way onto my desk on a gray Tuesday morning in November, where it waited, patient and indifferent, for someone to decide what it was worth. The fluorescent lights hummed. The clock on the wall marked the seconds with a sound like a small, tired heartbeat. I looked at Dennis Elmore. He was standing very still, in the way that people stand when they are concentrating very hard on not falling apart in public. His jaw was set. His hands, those clean, calloused hands, were pressed flat against the sides of his thighs. Not clenched, flat, as if he was deliberately keeping them open. As if he was trying to demonstrate, through the simple geometry of his body, that he was not a threat to anyone in this room. He wasn't. Anyone could see that he wasn't. And yet here he stood, accused, beneath fluorescent lights that hummed like dying insects, in a room that smelled of stale coffee and old paper, facing a fine that the math on the page told me he could not pay, without consequences I did not want to calculate. I had been in this business long enough to know that when the law produces a result that feels profoundly wrong, there are two possible explanations. The first is that you are missing information. The second is that the law itself has failed. In my experience, it is almost always the first. People rarely end up in a courtroom by accident. There is always a story. There is always a reason. The document tells you what happened. Only the person can tell you why. I set down the file. I folded my hands. And in the particular silence of a courtroom at the moment just before something important is said, a silence that has its own specific texture, its own specific weight, I asked the only question that has ever mattered to me in 31 years behind this bench. Mr. Elmore, he looked at me, fully, the way he had before, present, careful, rationing. The clock ticked. Why did you do this? He didn't answer right away. That was the first thing I noticed. Not the hesitation of someone constructing a lie. I have seen that hesitation 10,000 times, and it has a particular quality. A kind of interior calculation you can almost watch happening behind the eyes. This was different. This was the hesitation of someone deciding whether they had the strength to tell the truth out loud, in front of strangers, under fluorescent lights, in a room that had no business being this cold in November. His public defender touched his arm again. He exhaled once, slow and controlled, through his nose. And then he spoke. His voice was quiet, not soft, quiet. There is a difference. Soft suggests ease. This voice had nothing easy in it. It was the voice of a man who had learned to keep the volume low because he could not always trust what would happen if he let it rise. He said his wife's name was Karen. He said it the way people say the names of the dead, carefully, like the word itself is something fragile that might not survive the air. Karen had died 18 months ago. A car accident on the interstate, a wet morning in May, a truck that crossed the center line. She had been 32 years old. She had been on her way to work. He had 2 children, Caleb, who was 8, Maya, who was 5. He worked maintenance at a residential property company, 40 hours a week, sometimes more when they needed him on weekends. He did not say this with pride or with complaint. He said it the way you recite facts that have become so familiar they no longer feel like they belong to you. They are simply the coordinates of your life, the fixed points around which everything else must arrange itself. After Karen died, he had made a series of decisions. He listed them without drama, in the flat, sequential manner of someone who had thought through each one so many times they had worn smooth. He dropped the family health insurance because the premium was more than the rent, and he could not pay both. He canceled the streaming services. He stopped buying lunch and started making it when there was something in the house to make it from. He sold Karen's car. He moved Caleb and Maya into the same bedroom so he could rent out the second room for 3 months. An arrangement that had ended badly when the tenant stopped paying and he didn't have the money for an eviction attorney. He paused there. The clock ticked 4 times. Then he said, "The week of the 22nd, Maya had been running a fever for 2 days, 103 degrees. He had taken her temperature 6 times because he kept hoping the number would change. It didn't. He knew she needed a doctor. He knew she needed an antibiotic. He knew exactly what it would cost and exactly what he had. And the distance between those 2 numbers was the distance between where he was standing now and somewhere he could not reach. He had $11 in his account. He said that the way you say a sentence that has no other words around it, just the number, standing alone in the silence. I did not move. He had gone to the Marsh Avenue Plasma Clinic on the 22nd because he remembered seeing their sign on his way home from work. He had known, he said he had known, that he was not supposed to. He wasn't trying to claim ignorance. He had read the form the first time, back on the 14th. He understood the interval requirement. He had gone anyway. He had sat in the chair and looked at the ceiling and thought about Maya's temperature and the number 11 and the distance between them, and he had made his decision. The $50 he received bought the antibiotic, a box of children's fever reducer, a loaf of bread, and a carton of milk. He still had $4 and change when he got home. Maya's fever broke by morning. He stopped talking. The room was completely silent. Not the ordinary silence of a pause, but the particular silence that settles over a space when something true and heavy has been placed in the center of it, and everyone present understands that the air has changed. I looked at him for a long moment. Then I looked down at my hands. I am not by nature a man who performs emotion. 31 years on the bench will teach you to keep your face composed, not out of coldness, but out of respect. The people in front of you need to believe that the person making decisions about their lives is in control of something, even if only themselves. But there are moments when composure is simply the name we give to the effort of remaining present in the face of something that would be easier to look away from. This was one of those moments. I picked up my pen. I set it down. I removed my glasses and held them in one hand and looked at the middle distance for what I can only describe as the time it took me to make a decision I had, in truth, already made. I put my glasses back on. I stood. "Mr. Elmore," I said, "under the provisions of State Health Code 47B, this court finds you guilty of the cited infraction." I watched his face. It did not crumble. He nodded once, slightly, as if this was simply the next coordinate, the next fixed point around which everything else would now have to arrange itself. "And," I continued, "exercising the discretionary authority vested in this court, I am suspending the financial penalty in its entirety. No fine, no payment schedule, no mark on your civil record." The gavel came down. The sound of it, that single definitive thud, landed in the room like something final and right. Carol Reeves exhaled beside him. Rosa Vega, across the room, had stopped writing. She was looking at her hands. Dennis Elmore stood very still for a moment. Then he pressed his right hand flat against his chest over his heart and closed his eyes. It lasted perhaps 3 seconds, It was the most complete expression of gratitude I have witnessed in 3 decades in this building. I reached into the inside pocket of my robe, something I had prepared before the session, and I removed a folded piece of paper. I asked the bailiff to carry it to the defense table. On it, I had written the names and contact numbers of 3 organizations in the city, a family food assistance program that operated without income verification, a children's medical clinic that offered sliding scale fees for uninsured patients, a grief support and financial counseling service specifically for widowed parents. I did not make a speech about it. I did not explain it. I simply said, no one is required to do everything alone. The courtroom cleared in the way courtrooms always clear, slowly, with the particular shuffle of people recollecting themselves, gathering coats and folders and the various objects they had set down during the proceedings. The bailiff reset the chairs. Patricia collected the dockets. The space heater behind the door made a sound like a small, contented animal. I sat for a moment after the others had gone. I do that sometimes, when a case leaves something behind in the room. Not a residue exactly, more like a frequency, a vibration in the air that takes a little time to settle. I have learned not to rush it. The next case will come. The next file will be on the desk. The next person will walk through that door carrying the full weight of whatever brought them to this building, and I will owe them my complete attention. But first I allow myself this, a few minutes of stillness in which I acknowledge that something real happened here today, that a human being stood in this room and told the truth about his life, and the least I can do is sit quietly for a moment and let that mean something. Dennis Elmore had told me the truth. Not a partial truth, not a strategically edited version of the truth. The whole truth, offered plainly, without self-pity, without performance. He had not asked me for anything. He had simply answered the question I asked him. And in doing so, he had reminded me of something I try never to forget, that the people who come through that door are not abstractions, not case numbers, not violations of statutes. They are people who woke up one morning and found that the distance between where they stood and where they needed to be was too far to cross by ordinary means. Most of them did not choose the crossing they made. They chose the destination. They chose their children, their families, their survival. The crossing was simply what was available. I turned off my desk lamp. I picked up my coat. I went home. That was 3 years ago. I learned what happened to Dennis Elmore the way I sometimes learn what happens to the people who pass through my courtroom. Not through any official channel, but through the particular grapevine that exists in a city of this size, where enough people know enough other people that news travels in unexpected directions. Patricia mentioned it to me one morning the following spring, half in passing, the way she delivers information she thinks I will want to hear, but isn't sure I'll ask for directly. She told me that Dennis had contacted the Family Assistance Program, that he had done so within a week of the hearing, that he had been connected with the Children's Medical Clinic, and that Caleb and Maya were now covered under a municipal assistance plan he had not previously known existed, that he had attended 4 sessions of the grief counseling service and had, by all accounts, found something there. She used the word grounding, which I thought was exactly right. And then she told me the part that I have thought about many times since. 2 years after that Tuesday morning in courtroom 4, Dennis Elmore had begun volunteering with one of the organizations on the list I had handed him, the Family Food Assistance Program. He had started by helping with distributions on Saturday mornings, carrying boxes, organizing shelving, doing the kind of physical work his body was built for and his instinct required. Then he had begun helping with intake, meeting with new families, learning their situations, connecting them with the right resources. He had a particular ability, the program coordinator had apparently said, for making people feel that their situation was not shameful, that it was survivable, that someone in that room understood, not theoretically, but in their bones, what it meant to stand in front of a number you couldn't reach. He became, within 18 months, the volunteer coordinator for the program's East Side District. The same East Side zip code as his apartment. The same neighborhood where the laundromats are full on Sunday nights and the corner stores close early in winter. When Patricia finished telling me this, she picked up her coffee cup and walked back to her desk without ceremony, which is entirely characteristic of her, and one of the many reasons I value her presence in my professional life. I sat with it for a while. There is a version of justice that is purely transactional. You did this, therefore this happens to you. It is clean and it is consistent, and it requires very little of the people administering it beyond the ability to read a statute and apply arithmetic. I understand its appeal. Consistency matters. Predictability matters. A system that bends too easily in too many directions stops being a system and becomes something else entirely, something more vulnerable to the wrong kind of bending. But I have always believed that there is another version. One that asks not only what happened, but why. One that recognizes that the people standing in front of it are not the sum of their worst moments. That context is not an excuse, but it is always, always a fact. One that understands that the most powerful thing a court can do is not always the most severe thing. Sometimes the most powerful thing a court can do is see someone clearly, name what it sees, and offer them a path forward rather than a wall. Dennis Elmore sold his blood to feed his children. He broke a rule that exists for legitimate reasons, in service of a purpose that required no explanation to anyone who has ever loved someone they were responsible for. I chose not to fine him $800 he did not have for an infraction that cost him $100 he desperately needed. And 3 years later, he was standing in a church hall on Saturday mornings, carrying boxes of food to families who reminded him of himself, and making sure they knew the names of the organizations that had changed his life. Because he understood, in a way that no training manual could teach, that information given at the right moment to the right person in the right tone is not just information. It is a door. I have spent 31 years trying to leave doors open rather than close them. I have not always succeeded. There are cases I replayed differently in my memory, sentences I would have calibrated differently if I had known then what I know now, questions I did not think to ask until it was too late to ask them. That is the nature of this work. You operate with what you have, in the time you have it, and you try to choose the most human option available to you in that moment. On a gray Tuesday in November, with a broken heating system and stale coffee and a file that told me everything except what I needed to know, I think I chose correctly. I think Dennis Elmore would agree. If this story stayed with you, if you found yourself somewhere in the middle of it, thinking about someone you know or something you've lived, then you already understand why these cases matter. There are thousands of Dennis Elmores. There are thousands of courtrooms where the wrong question gets asked and the wrong answer gets accepted and a door gets closed that should have opened. Subscribe if you want to keep sitting in this courtroom with me, because the next case is already on my desk and it will ask everything of us. If this story stayed with you, take a moment and ask yourself honestly, have you ever been in a position where the only options left were the wrong ones? Where every door that should have been open was closed, and the one thing you did to keep going was the one thing someone decided to hold against you? Have you ever stood in a room, a courtroom, a workplace, a kitchen at midnight, and felt the full weight of a system that could see exactly what you did, but had no interest in understanding why? And have you ever received from a stranger a piece of paper with a few names on it, and discovered that what looked like a small gesture was actually someone telling you, you do not have to carry all of this alone? Tell us your story in the comments. Every single one gets read. And if you believe in the power of compassion, second chances, and the kind of justice that asks why before it decides what, subscribe to this channel, because the next case is already on the desk, and it will ask everything of us.